Yes, Mr. Tony.
So I'll aim then to deal with ground two, the secondly,
ground two.
well, exactly.
Yeah.
Then the later injuries, and then the father's appeal. In relation to ground two, well, we've dealt with that in our skeleton as a whole piece in response to grounds 1 to 6, but at B52, our response begins, and from B53, which is paragraph 28, we have set out in respect of each of the relevant dates, 24th of April, 3rd and 4th of May, and the 5th of June, matters which we say the judge properly and fairly identifies as either inconsistencies or a lack of coherence in the mother's account. For it's right to say, in particular, in relation to the 24th of April, he relied upon both. That is, it made no sense and it was riddled with inconsistency. And therefore, it's our submission that when the court comes to consider the merits of ground two, it does so against that background, against this context, that is, numerous findings made by the judge, which the judge was entitled to make, and which might fairly be described as unimpeachable findings. And it's with that in mind that one turns to the judge's paragraph 173. At E25. Because by the time one turns to by the time one gets to paragraph 173, the judge has already considered many of the inconsistencies upon which he later relies, just in relation to the 24th of April, but also his concern at 172 about the evidence given in respect of the radiator. The radiator evidence is significant. It's significant firstly because it was not highlighted previous to cross-examination, prior to cross-examination. And so it was an important detail about which a witness would be expected to be able to give a coherent answer, but about an issue that perhaps couldn't be planned for. So the judge was right to rely upon that as an important factor illuminating his inquiry. And there were two references or 2 points he took from that, which he was entitled to take. And one was the improbability of the timing of the radiator coming on and going off. But also, if the radiator was on, the improbability of the mother's account that she stood by and watched the child approach the hot radiator. And so that had relevance to the judge. So all of those matters are raised by him until before one gets to paragraph 173. 173 might mean of even more concern than 172. It might mean of even more concern than 168 to 172. In our submission, it appears to be of more concern than 172, as 172 relates to the radiator incident, the heat potential from the radiator and the mother's response to that, which is perhaps at the lower end of the list of inconsistencies and lack of coherence in her account. But then he goes on from there. That's not where he then reaches his conclusion. He goes on to say what is really worrying. So he ups the anxiety, the judicial concern, in the next paragraph. And his anxiety is a fundamental one of not being able to understand what the mother was saying. So it goes back to his fundamental point about mechanism, which is he did not have a clear understanding of what this mother said had happened, because it just made no sense to him. And he took comfort from the fact that it made no sense to the experts either. So he was entitled to do that. And then he goes on from there to look at the wider canvas of evidence in relation to matters arising in relation to the 3rd and the 4th of May, and then in relation to June. So therefore, it came back to our skeleton, having set out all of those inconsistencies and all of those features of the mother's evidence which were unsatisfactory. Our paragraph 29 at B55 is that he was entitled to find inconsistency about the most significant aspects of the alleged accident in April, find inconsistency and false evidence about the delayed presentation, because the mother, he found, lied about what the GP had said, to find inconsistency as to the potential causes for the new injuries on the 5th of June, to find inconsistency and false explanation for the removal from hospital, to conclude, therefore, the accounts were not credible or coherent, and to reject those accounts. So all of those conclusions he was entitled to come to on a very broad spectrum, on the basis of a very broad spectrum of evidence. So is it not rather like what one was used to hearing in respect of circumstantial evidence, the various strands of the rope that make up the strength of the rope? The more strands, the stronger the strands, the stronger the ultimate rope. In this case, stepping back, the Guardian says, well, one might sever one of the strands of the rope, but it still leaves a rope that's strong enough to sustain this judgment. In other words, seen in its proper context, with so many inconsistencies and such a lack of coherence, with evidence of dishonesty in respect of presentation, advice given, and removal from hospital, the judge was certainly entitled to come to the conclusions he did. So if one stands back and asks oneself the ultimate question, which is the judgment wrong, then in our submission, taking account of all of the evidence, the ultimate findings can't be said to be plainly wrong. They are based on very many significant and unimpeachable conclusions in relation to all the subcategories we've identified as to pointing towards inflicted as opposed to accidental injury. So for all those reasons, notwithstanding the anxiety about the judge's view in respect of the 2 marks to the child's face, we invite the court to uphold his findings in respect of the April and other allegations. Can I just, before I leave that point, just deal with the paragraph?
You set out in paragraph 32 of your written submissions the Guardian's analysis of that,
Yes.
the judge's reference to the photograph of the grazers.
Yes.
And you fairly raise questions about the judge's reliance on that.
Yes.
And your submission then essentially goes on to paragraph 34.
Yes. So that
the reason I'm drawing your attention to paragraph 32 is that paragraph 32 seems to reflect a slight divergence between you and the local authority.
yes,
And that you recognise a number of features. And indeed, you say the issue was not raised in the course of submission, so obviously it didn't feature as a significant element of those submissions.
No. Can I deal with the written submission?
Yes.
That Justice Cobb referred to, which is paragraph 26 of the closing submissions on behalf of the Guardian, D8, 1, 2, 3. The intention behind this paragraph was to draw the court's attention to effectively the neutrality of the expert evidence. So the first part doesn't deal with the two vertical grazers. The second part of the paragraph says it's equally difficult to picture a mechanism that could have caused this injury in an inflicted way. And
I see.
so it's really to illuminate or to identify to the judge that the expert evidence was neutral, and therefore I think we are bound to accept that the judge, as it were, picking out the reference to the marks of the face is a departure from that invitation to treat the expert evidence as neutral. So that's why we're concerned about that aspect of the judgment. But it is not a concern that leads us to invite the court to do anything other than endorse the ultimate conclusions of the judge, which are based on firm territory. The second matter, if I may then, is in relation to the later injuries. The point is, I think, this, that there was no dispute but that this child had suffered some injuries later on, necessitating the attendance at hospital on the 5th of June. And we know that, not least because I think the mother accepted it, but we have the clear evidence of the doctor, the paediatrician, Dr. Caldwell, refers to it at, and it's referred to in the judgment at E16, 97K. On the 5th of June, J appeared to have suffered new injuries of a linear abrasion, also the hemorrhage in the eye, which could have been caused by a new injury or trauma. It's also right to say that the expert evidence from Mr. J. Marin was entirely neutral on this point, in the way it had been, as it were, in April. One looks at what he had to say about the later injury, and this is in his written report. So it's PDF 365, I think that's F144. Yes, F144.
Sorry, I've got two lots of numbers on this, so
Yes,
one
I'm sorry.
stamped over the other, so I'm sometimes not sure I'm on the right page. F144, I think I've got that.
Yes, I hope that.
Starting at the line 425 at the top of the page.
Yes,
Yeah.
Thank you. So the first new question on that page. The history given of the initial event in April could be a rare but possible cause of the very exuberant scalp swelling and bruising seen after this. The further events may be caused by rebleeding and redistribution of the initial injury. In such a situation, I would consider it unlikely but possible that a further impact in June in the cot may have set out recollection or recollection of scalp and subgaleal collections with relatively lower levels of energy. So in relation to a subsequent trauma causing the further swelling, that was possible, but that was unlikely. So one has the swelling, which is possible but unlikely. One has the linear abrasions, about which there seems no dispute. But one certainly had a child with new injuries. And so the judge had to decide whether or not most of the injuries might have been, as the expert evidence permitted, on a finding of a benign fall in April, whether they were a result of that or not. But he also had additional injuries, which were not explained by the earlier April fall. But he fairly starts the analysis of that at 215 at E29. Because he's clearly at 215 taking the matter from the April incident through to the May and on to the June. And over the page, he says that he goes far in the parents' favour. He says that these are all points which cannot be dismissed and which could go towards an outcome in favour of the parents' case. So he's looking there at the whole picture from April through to June and the potential role that the, if benign, fall in April would have had. But what causes him to part from that course, or that way of looking at matters, is what he then sets out, which is the wider canvas. And then, of course, he sets out all of the, many of the references that we referred to in the skeleton of inconsistency and lack of credibility in the accounts given. Ultimately, by the time he came to consider the June incident, if he had decided that April was an inflicted injury, as he was entitled to do, we say, then he was entitled to take account not only of the inconsistencies, the attempts to avoid medical examination on the 5th itself, but also an earlier attempt to failure to take the child urgently to hospital in May. All of those factors weighed very, very heavily, and from which he was entitled to infer the mother's culpability for the injuries in June. And looking only at the injuries in June, there was a picture of inconsistency. The most obvious one was the initial account made no mention of the hard object, the music box, which is an astonishing omission, if that might have been the cause of the child's injuries, against the backdrop of so many concerns and injuries over time. So in our submission, he deals with that satisfactorily. He was entitled to conclude that there were a number of inflicted injuries. And indeed, it's right to say, is it not, that when one looks at the evidence of Mr. J. Marin, he is looking at two propositions. He's looking at a benign fall in April, an accident, or a series of inflicted injuries, because that was the groundswell of the medical opinion. Those were the two options. Of course, it's always possible there was a third, and the judge expressly says he's looking at a potential for some accident in amongst all of the inflicted. But really, the reason why Mr. J. Marin was talking about a lack of, or the unusual aspect of the case, the lack of any intracranial damage, was because he was considering, on the basis of all the other experts' evidence in his own view, that we're either looking at the April fall, or we're looking at a series of inflicted injuries. So that was the task the judge had to decide, really. That was the main issue for him. And finally, the father's appeal. So we deal with that separately in the skeleton, and I think the way I'd seek to characterise the judge's approach is that from the bottom of B62, I've set out the matters that the judge concern the judge and the findings he made about some of those matters. So in paragraph 62, he considered the messages. He was entitled to make the conclusions he did from those messages. He was entitled to look at the conduct of the parents and make conclusions in relation to that. He sets out what those conclusions are. So, for example, he was entitled to, at the bottom of end of paragraph 64, to reject the father's account that he had apologised, for example, for his anger. All of those were matters he was entitled to conclude. He was entitled in the next paragraph to conclude and to find that they must have talked about the instance, and therefore they were not telling the truth, both of them, when they said they had not. And so those were, as it were, prior findings, which lead him on then to his ultimate inference drawn from the father's behaviour on the 5th of June. So it was an entirely permissible inference, taking account of his findings he'd made against both parents up to that point, and based upon his assessment of both parents in evidence. So in our submission, the father does not make good his complaint about the judge's assessment of him and the findings made in respect of him. also the Guardian advised the court to dismiss both appeals. But of course, if the court is against us, we, I think, concede that probably it would have to be a retrial. Those I think are the submissions, unless there consists further.
Thank you very much. Who's going next, Mr. Luvanoni or Mr. Badgie?
Nothing on behalf of the father
Right.
in response of those
Thank you.
submissions.
My lord, two very short points by way of reply. The first is really on a point of information in relation to the sequence of events leading up to the handing down of the judgment on the 16th. It was the case that the judgment was circulated in draft in advance. That gave us, on behalf of the mother, the opportunity to draft grounds of appeal, which we saw fit, and out of courtesy to the learned judge, to send to him on the Sunday before the handing down of the hearing. We have recirculated that email to the parties. It was copied to the parties, which effectively said, and I'll read it, I can hand it in. I'm instructed to apply for the permission of the court to appeal the findings of inflicted injury to the Court of Appeal. I enclose our draft grounds of appeal pending the grant of permission and would hope that the court will be in a position to consider the application tomorrow. And the grounds of appeal were drafted in exactly the same terms we presented to this court.
So you did complain about the finding based on the photograph?
Yes, we complained on a macro level,
Yeah.
Not on a micro level, because I think I took the view that probably following the quite firm guidance from this court in relation to the merits of opening up the opportunity to re-argue the case.
Yeah, so-called clarification.
It didn't seem like a clarification point because it was a headline finding. And so many of us take the view that simply re-arguing it is not appropriate, not proportionate, and fundamentally unfair. So it wasn't a clarification point, but the learned judge did have, and my learned friends, to be fair to them, had notice of what we were complaining about before the handing down of the judgment.
Understood.
So that's the first point. The second point.
Before we come to the second point,
Yep.
just on the detail, the judgment is dated 9th of September on its face.
Yes.
Was that the date of the draft? And the 6th, because it's otherwise been referred to as the judgment of the 16th of September.
Yes, this is where my review of my emails and what I was doing lets me down. I know I was there for the formal handing down, which was on the 16th, and which was the date upon which the application for permission appeal was made to the learned judge. So that might be a mistake because the formal handing down probably took place on the 16th.
16th.
I think everybody's agreeing with me on
It was emailed by the judge to us on the 10th.
that. Emailed on the 10th.
Thank you.
Thank you very much.
And I think I'm right in saying, correct me if I'm wrong, that there is no formal order from the judge dealing with the findings that were sought in the Scott schedule.
That's correct.
That's correct. And there should be, as a matter of good order, be a recital to an order particularising the findings in the way I think identified by Lord Justice Ward many years ago. Yes.
The only order that was made was at C1, isn't it?
Yes.
It was just the case
That
management.
was just a case management order, yeah.
Yes. The other very short point was only to say this, that we haven't focused very much in our oral presentation on the role inconsistency played. I know that it has featured significantly in the submissions you've heard from others. Or I'm just going to remind the court, from paragraph 30 onwards in our skeleton argument, we address it. We already made submissions to the learned judges to the significance of inconsistency in the overall evaluation. And the headline point that we made is that simply the learned judge was too harsh. And his expectations of consistency from parents such as this and a mother such as this, and the circumstances in which she had originally given an account initially to the hospital and otherwise in the aftermath of having witnessed this injury, was unrealistic and not really in line with real world experience. I accept fully, it's up to the learned judge. He acknowledged the Lancashire case, my Lord Justice Peter Jackson acknowledged all that. It's for him to assess the extent to which he should make allowances for that.
The difficulty with that submission, if you'll forgive my saying so, is that what Mr. Justice Peter Jackson was doing was describing the role of the trial judge. And as I put to one of you, I can't remember which one, we are an appeal court. And the extent to which a judge does or doesn't take a view about inconsistency is essentially an evaluative judgment based on the whole of the evidence.
Well, I have to take that point. Yes. Yeah, the whole of it, which of course included what we would submit was a pretty clear background canvas in relation to, because there are parts of the judgment where he accurately reflects the very positive things said about the mother and her parenting as a role as a nurse. All that really comes down to whether or not this is the sort of person who would injure her child repeatedly and then lie about it in the way that she has, so as to open the door to the findings that I've made. And so that's essentially was our submission in the court below in relation to that. I very much take the point, well, this court says, well, ultimately, it's well established that's a matter for him and not for us. That's all I would seek to say by way of reply to my lord.
Well, thank you all very much for your economical submissions. We'll obviously go away and think about this because it's of great importance to the appellants. We are aware that time presses. We will hope to get you something soon. It will be a draft judgment subject to the usual embargo, which is strictly enforced these days. We would hope that in the light of the draft judgment you will be able to agree in order disposing of the appeals. In the event that you can't agree in order, please make short written submissions and we will make the form of order that we think is appropriate.
Indeed, my lord.
Thank you all very much.
Court rise of April.
I think the word at the moment